expert evidence, expert witness, express contract, express permission, express provisions, expressio unicet, extrajudicial confession, fact and circumstance of the case, facts and issue, facts relevant to the issue, failed to bring home the guilt of the accused, failed to establish, failed to prove, failure to appear, false arrest, false pretenses, false witness, felony murder, file documents, financial affidavit, find a verdict, find for defendant, find for plaintiff, first class magistrate, first defendant, first mortgage, first plaintiff, first point of consideration, fixed term of contract, Food Adulteration Act, for cause, for example, for how long, for how many long, for how long a time, for illustration, for instance, for partition and position, for such other reliefs, for the foregoing reasons, for the purpose of court fee, for the reason stated above, for the same argument, for you to determine, for you to resolve, force measures, forged document, forma puperias, found guilty of the offence, framed, read over and explained, framed, read over and explained to the accused, fraud swindle, free and clear, from day to day, from door to door, from place to place, from street to street, from the evidence discussed, from the evidence discussed above, from the evidence of prosecution witness, from time to time, from your memory, from your recollection, full legal powers, full settlement of the claim, functus officio, fundamental rights, gentlemen of the jury, gentleman's agreement, geographical area, gift deed, give notice, go into effect, go legit, go on record, good behavior, goods and chattels, government officer, government order, government pleader, grace period, grey area, gross negligence, grounded in fact, grounds for, guarantee deposit, guardian ad litem, guardian of the minor, habeas corpus, had there been, Hanafi law of inheritance, has no manner of rights, title or interest, has no means to maintain, have you given, have you received, having regard to the age of the accused, having carefully considered the evidence, having regard to the age of the offender, having regard to the fact and circumstances of the case, having regard to the gravity of the offence, having regard to the probability of the case. He further states, he has argued, he has contended, he has further argued, he has further contended, he has further pleaded, he has further stated, he has further stated in his evidence, he has further urged, he has pleaded, he has stated in his evidence, heard in part, heirs, executors, administrators, and assignees, hereinafter referred to, High Court of Andhra Pradesh, High Court of Judicature, High Court of Judicature at Bombay, High Court of Karnataka, High Court of Tamil Nadu, Hindu Divorce Act, Hindu Father, Hindu Joint Family, Hindu Law, Hindu Law of Inheritance, Hindu Marriage Act, Hindu Rights and Customs, Hindu Undivided Family, Hindu Wife, Hindu Women's Right to Property Act, Hire Purchase Agreement, His Lordship of Allahabad High Court, His Lordship of High Court of Kerala, His Lordship of Supreme Court, Homicide, Honorable Court. Honorable Court may be pleased to call for. Honorable Court may be pleased to decree the suit. Honorable Court may be pleased to direct. Honorable Court may be pleased to discuss. Honorable Court may be pleased to order. House breaking. House breaking by night. Hug jury. Husband and wife. I am of the firm opinion. I am of the firm view. I am of the opinion. I ask the court to charge. I ask the court to charge the jury. I cannot remember. I charge. I could not tell whether or not. I decline to charge. I do not know whether. I do not say. I do not see. I don't know. I accept. I accept to the refusal to charge in the language request. I have already held. I have no doubt. I have no hesitance. I have no hesitation to hold. I have no other option. I have not. I instruct you. I may take this opportunity. I refuse to charge. I refuse to charge as request. I said they were not. I shall discuss the evidence. I shall now discuss the evidence. I swear that. I take an exception. I think there were. I think there were. I would not. I would not be sure. I would not say. Identification parade. If plaintiff knew. If you determine. If you find. If you resolve. If you shall find. Illegal, unlawful. Illegal gratification. Immovable property. Implement an agreement. Imprisonment for a period of. Imprisonment for a term of. Imprisonment for life. Improper valuation. In a suspension. In abeyance. In accordance with. In arrears. In bad faith. In case of controversy. In consideration of. In considering. In custody of. In debt. In such other manner. In support of his contention. In the act of. In the alternative. In the case of the complainant. In the cross examination. In the evening. In the instance case. In the interest of justice. In the language request. In the light of my finding. In the light of the finding. In the light of these discussions. In the morning. In the public interest. In the right. In the wrong. In this case. In trouble with the law. In trust of. In view of these incognitives. In what capacity? In your capacity. In your determination. in your examination, in your opinion, in your testimony. Indian Arms and Explosive Act, Indian Companies Act, Indian Constitution, Indian Evidence Act, Indian Penal Code, Indian Railway Act, Industrial Disputes Act, Industrial Property, Inherent Jurisdiction, Inherent power of the court, Inquest Report, Inspector of Police, Insult, Annoy or Intermediate, Insult, Intermediate or Annoy, Interested Testimony of Prosecution Witness, Interim Order, Intermediate, Annoy or Insult, Intermediate, Insult or Annoy, Invention of Privacy, Investigating Officer, Irrefutable Laws, Irrefutable Presumption. Is there any business? Is there any doubt? It is argued by the learned advocate for the plaintiff. It is argued by the learned counsel appearing for the defendant. It is argued by the learned counsel appearing for the plaintiff. It is argued by the learned counsel for the. It is argued by the learned counsel for the accused. It is argued by the learned counsel for the accused appellate. It is argued by the learned counsel for the defendant. It is argued by the learned counsel for the defendant appellant. It is argued by the learned counsel for the petitioner. It is argued by the learned counsel for the plaintiff. It is argued by the learned counsel for the respondent. It is case of the plaintiff. It is claimed. It is clearly established. It is contended. It is contended by the learned advocate for the accused. It is contended by the learned advocate for the defendant. It is contended by the learned advocate for the petitioner. It is contended by the learned advocate for the plaintiff. It is contended by the learned counsel for the accused.